Kenya's horticultural sector, this COVID-19 pandemic could not have come at a worse time. As more and more European countries impose restrictions on business and movement, Kenya's flower industry says that most farms have cut shipping volumes to under 70% of their available capacity, and a sizable number have suspended exports altogether. In 2018, the sector reported a 38% increase in sales to just over $1.1 billion, and that's just from cut flower sales. This outbreak is likely to quash rising revenues, putting jobs and related enterprises at risk. But April is also a vital month in Kenya's tax calendar, usually as the balance of income taxes for the prior year have to be settled in that month. And April is just around the corner. So with more restrictions on movement and trade coming into effect across countries, what legal options are available to companies, even those that are providing what some would argue are essential services? That's a question I put to Beatrice Nyabira. She's a partner at IKM Advocates.
Well, I think, again, the context has to be considered. And it may be that you're not declaring a force majeure unless that is allowed in the contract. You may then be pleading a different sort of relief that you're seeking. It could be that you're saying it has become impossible for me to perform because I don't have staff. So, I mean, the contract has been frustrated, or some other form of remedy. Force majeure is very strictly defined, but there are other remedies that one could possibly plead, considering the current circumstances where we're seeing, for example, staff not being able to come to work. I think the borders, more or less, flights from certain countries are not able to come in. We're not receiving cargo at the port. So there are other remedies that one can plead, such as frustration. Following that, you must also demonstrate that, that you're willing to perform and keep your counterparty updated as to what is happening. So it's not enough that you would cite, some force majeure and then go mute for 2 months or 3 months. You must keep the other party updated, and as soon as possible, as soon as you're able to perform, you must notify the other party and resume performance. Now, that is just one option.
But what about the enforcement side of it? Because one of the main issues that always comes up when we talk about the Kenyan legal system is just how clogged the court system is. Might it be easier to actually go down the arbitration route to essentially try and resolve any disputes that will inevitably arise, as you point out, from having to renegotiate all of these contracts?
I think the good faith negotiation would typically be the first step. We wouldn't recommend court action because court action is really at the extreme end of the scale. So I think the best way to approach this would be for parties to meet and make good faith efforts to try and negotiate. And where they're not able to reach consensus, there's other mechanisms in between before you get to court action. Arbitration is one of them, but again, it depends on whether it's allowed or envisaged under the contract, because a lot of these arrangements are already governed by contracts. And contracts are very specific because they're meant to guide on what should happen in different scenarios.
Right. What about the tax laws involved? Because any business will have obligations to suppliers, but at the same time, you've got to deal with local tax authorities either on a monthly or quarterly basis. Is there any flexibility built into Kenyan tax laws when it comes to postponing payments, be that personal income tax, corporate income tax, value-added tax, and so on?
Yeah, well, that's an interesting question because, interestingly, the tax laws do have provisions. I think the Tax Procedures Act has provisions that allow for extension of time, and those are captured in the laws. But however, let me qualify that because, for example, they talk about deferment of payment of tax. But what was envisaged in drafting the law was, for example, if you're hit by a huge tax assessment that you are not expecting. I mean, we've seen what the tax cases look like. I think in such scenarios, it was envisaged that you could approach the KRA and seek, to provide a payment plan to them, including in the case of other taxes. I think the law envisages that you could make an application providing grounds as to why you need some extension of time to make payment, and the commissioner has some discretion in that regard. But remember, this was envisaged to be a one-off scenario. It was not ever thought that, all taxpayers, for example, would require such kind of flexibility. So, well, there is provisions. I don't think it was ever envisaged to be used in this manner.